Good evening, everyone. Welcome to the Simsbury Library, the best business library in the state of Connecticut. Tonight's topic is intellectual property, and it's being sponsored by both the library and SCORE. For those who don't know SCORE, it is a mentoring and counseling organization made up of volunteers and works in conjunction with the Small Business Administration. The key information is that the mentoring and counseling is free and confidential to all small businesses. First, I'd like to introduce the head of the business area of Simsbury Library, Sarah.
Loudenslager.
Yes.
Mouthful.
And Sarah could answer, if not later, anytime, her business questions. Her office is right upstairs. And since we're running slightly behind, I'd like to introduce our guest of honor tonight, the speaker, who is an attorney with the firm
Cantor, Colburn.
Cantor, Colburn, and they specialize in intellectual property. And Mr. O'Brien happens to be the chair of the intellectual property section. So please, Mr. O'Brien, take it away.
Okay, thanks. All right, thank you. Okay, well, thank you for having me tonight. So I head up our transactional group. The firm as a whole, we do intellectual property of every kind. So I head up we do a lot of licensing, in and out, software license agreements, all those types of things. So I want to talk to you about a couple of different things tonight. First, talk about the different categories of intellectual property. There's really 4 basic types, and kind of walk through each one, how they differ from the other, and how they're related. I want to talk a little bit about ownership of intellectual property. Some of you may own your own businesses, you develop intellectual property, you may use employees, you may have consultants. Do you own your IP? Do they own their IP? How does that all work? Then I'll talk a little bit about, it's probably a little bit more focused on patents than the other 3 types of intellectual property. So I'll talk about what a patent covers, what it doesn't cover, and what it actually does cover. And then we'll talk about, well, how do you get a patent? What's the general process? What are the costs? What should you be thinking about as you go through that process? And then once you have your IP, you own your IP, how do you make money at it? How do you commercialize it? What are the different things you should be thinking about, from licensing, exclusively licensing, non-exclusively, all the different types of things you should be thinking about. All right, so the first, so there's 4 categories, basically: patents, copyrights, trade secrets, and trademarks. So let's walk through each one. So first on patents, there's 2 kinds of patents. There are essentially 2 kinds. There's utility patents and there are design patents. Utility patents covers an idea, and an embodiment of an idea. Like if I have if you take a chair, and if I have a patent claim that covers a seat, it covers 3 or 4 or more legs connected to the bottom of the seat, and a back coming off connected to the top of the seat. And those are my general claims, and that's my idea. There's a lot of different embodiments with those claims that you can make a chair. You can have the back in a specific shape, you can have 5 legs. As long as I have 4 legs, a seat, and a back, it covers my idea. So it's a pretty broad concept, and that's what a utility patent covers. A design patent covers, as you would think, the design of an article, the shape of it, the way it looks. It doesn't cover the idea of the article itself. It's the design of it. So the terms are a little bit different. For utility patent, it's 20 years from the earliest filing date. That's new over the past couple of years, but going forward, it's 20 years from the earliest filing date. Design patents are 15 years from the date of grant. So in March of 2013, things changed dramatically in the IP world. And the way it works today, we've kind of conformed to the rest of the world. It is a race to the patent office as to who actually gets a patent. So if there are 2 people out there that have the same idea, coincidentally at the same time. If you file your application first, the other guy files theirs the next day, you win. You get the patent if you're successful in actually going through the process. It was much different years ago. You could actually, it was really who came up with the idea first. It didn't matter who filed first, but that's all gone now. Okay, so patents are territorial. It just kind of as a side note, if you have any questions, please ask. Yeah.
The utility patent, it's a novel. Is that like a written novel or?
Yeah, so good question. So a utility patent, it covers things that are novel and non-obvious. Novel means think about it this way. There's not one piece of prior art. There's not one patent out there, let's say, that shows everything that you're claiming in one document. There's no one document out there, no one piece of what we call prior art that shows exactly what your invention is. So if it's not been done before, it's novel. When it's non-obvious, what that means is there could be two pieces of prior art out in the world. Where if I have, let's go back to my chair example, there's one patent that shows a seat with 4 legs. It doesn't have a back on it. There's another patent out there that shows kind of a stool with a back on it. And if I combine them up, I get everything that's shown in that my invention is. So that's obviousness. So, and we'll talk about that when we talk about the patent process. And you're always overcoming. You're trying to show the examiner that your invention is novel and it's not obvious. But I'll talk a little bit more about that. So patents are territorial. There's no one worldwide patent. So if you want to get protection in the United States, you need a US patent. If you want to get protection in Germany, you have to get a German patent. There are processes in place in the world through what's called the World Intellectual Property Organization, where you can start the process and start the prosecution process kind of at a high level, not really choosing what country you're going to go into, but eventually you have to take those patent applications and go into each particular country. So it gets very expensive to get worldwide coverage for your invention.
So does someone have protection if, let's say, they get a U.S. patent and then someone over in Germany gets wind of the invention and they file a patent in Germany?
So if you have just a U.S. patent, your protection is nobody in the U.S. can make, you can prevent people from making, using, and selling in the U.S. You can't stop them from doing anything in Germany. So can they attempt to get their own patent application? Sure. If you are actually trying to get your own patent application in Germany as well, and you have already filed in the U.S., you would be first, so you'd have first priority. But you really can't stop them. If you don't have a German patent, you can't stop them from doing anything in Germany, as long as they stay in Germany or they stay outside the U.S. That's why companies where if you're going to sell in the U.S., but you may have a big business in Germany, you may want to get patents in both countries. And if you're going to manufacture in China, let's say, you may want to get a Chinese patent. And you really, and companies need to go through that analysis. Where do I get the most bang for my buck, and where do I spend that money in the world? And so scope of protection on patents, I'll talk a little bit about this more, but it's counterintuitive. It does not give you the right to make the thing that you have a patent on. It gives you the right to exclude everybody else from making it, using it, and selling it in the United States. So I'll walk through that. It's counterintuitive. I have an example I think it'll make it a little bit clearer. Any questions on any of that? Yeah.
With the utility patent being good for 20 years and the design for 15, at the end of that term or shortly before, are you able to renew that, or it's a one-shot?
No, it's done.
Okay.
So the trade-off is, the government gives you this monopoly, let's say, to exclude everybody. The trade-off is you are to tell the patent office exactly how your invention works, with enough detail that anybody else can go out there and make it. And the trade-off is you make that information available to the public, so everybody else can look at it and they can start to develop it and make improvements on it. And that's that's really the idea behind patents. Yeah.
Suppose you have a utility patent and it's patented in the United States and the United Kingdom, and then somebody's manufacturing it in Germany. You don't have any coverage there. Somebody's selling it in the UK then, but you have coverage. Say, suppose the German company starts to sell it in the UK. What can you do to stop them?
So in that scenario, you would have an action in the UK for infringing the UK patent. You can't stop them from making it in Germany. If you had a German patent, you could stop them from making it. You can go to a German court and get the court to tell them, stop making that.
The German court you go to a German court.
You would go to a German court in that action to stop them. And even the Europe's a little bit different. They do have some combined courts, but let's put that aside. If you have just the UK patent and they're selling in the UK, then yes, you could have an action in the UK for that. And kind of a nuance to that, in the US, you can prevent, if you have a US patent, you can prevent the importation of products. So if you have just a US patent, they're making it in China, but they're importing it, you can stop it at the border. Well, you have a cause of action, and you also, there's what's called the ITC proceedings, is you can actually go to this administrative agency, which is the ITC, and have them stop it at the border before it even gets into the US. So it's a pretty powerful tool to have a US patent if your focus is in the US. All right, copyrights. So copyrights are different. Copyrights cover original works of authorship that are fixed in a tangible medium. So going back to the idea of the chair, if I have the idea of a seat, a back, and 4 legs, while the patent covers the idea, a copyright just covers the actual expression of the idea. Let's take a better example. If I make a painting of I don't see a sunset up there, but if make a painting of a sunset, I don't have now protection over, or I don't have a monopoly on preventing everybody from painting sunsets. But I have a copyrightable right in what I just painted, and in that particular tangible expression. Yeah.
So copyright, that would be automatic.
Right. So
If you take a photograph, you have copyright as soon as you snap that picture and make the image.
exactly. As soon as it's fixed in a tangible medium, you have copyright protection. So for copyrights, you don't have to register them to get that protection. There is a process for registering at the U.S. Copyright Office copyrights, and it does have some advantages. For example, let's take the painting. If I'm not a famous artist, I make my painting and somebody copies the exact same thing and they sell it. Well, what are my damages? Nobody's buying my painting, so there's no actual damages. So one of the benefits of registering is you can get what's called statutory damages, and there's a federal statute that says if per copy it could be X amount of dollars. So you don't necessarily have to prove you were actually damaged, because sometimes that's hard to prove in copyrights. So you can choose to go after these statutory damages, but if you don't register in time, then you don't have that ability to get those statutory damages. The other, well, I wouldn't even say benefit, the other requirement is if you want to assert that copyright, if you think somebody's infringing, you have to get a registration before you can go into federal court to actually assert it. So that is a requirement.
They use that for the movie industry to prevent like bootlegging and illegal reproductions and stuff?
Sure. So we represent Fox, and we'll get their movies before they're released. We bring them to the Copyright Office, and yeah, we get them registered. Yep. Yeah.
Okay, tangible. What about ebooks? Can you copyright your ebook? It's not tangible.
Yeah, it's a good question. Yes, you can. You can copyright web pages. You know, even though it's in electronic form, it is a tangible expression. So it's more limited than patents, just the expression of the idea. And copyrights comes with a bundle of rights. You can prevent others from copying, from distributing, from modifying your work. If you write a novel, somebody can't change the story just a little bit, but still it's essentially your same novel, you have rights to prevent that. And if let's say you come up with a play, you have the right to display it, to publicly perform it, and you can prevent others from doing that.
Do other nations have the same view of this as the U.S.?
In what sense?
Suppose you do a painting in the United States and it's for sale all over some other country.
Yeah, so it's a good question. So there's what's called the Berne Convention. So that's kind of most countries have signed on to this convention to make the laws, the copyright laws, kind of uniform. So you should have, it really comes down to different countries in the laws, but they should all conform to this Berne Convention. So you should have protection in those other countries, yeah. Yeah.
So you start off saying if I took a picture, it's copyright and I don't have to do anything extra. If I wrote an ebook, is it copyrighted? If someone copies it and sells it, how do they know that? I have to register, right? To prevent someone else from copying it, do I have to register it to a copyright organization?
Not to prevent, well, let me say it this way. If somebody copies your book, in order for you to take action, which would be filing a federal copyright infringement lawsuit, you have to have a registered copyright. You have to actually, a nuance to that is some courts say you can have registered for it, you just don't have the registration yet. Other courts say you have to actually have the registration, but you have to, in those courts that say the application, the filing of the application is good enough, you at least have to have done that. But that's the minimum standard. Most.
Is it back to first come, first serve? So if I write something, someone else gets their hands on it, they copyright it before I do. They own it, not me?
Yeah, no, good question. So copyright's different than patents in timing. Somebody can, let me say it this way, somebody has to know about your copyrighted work to have seen it, to copy it. If they happen to come up with the exact same thing, you may not have a claim against them for copyright infringement. Patents are much different. Patents, you don't, if you're making a product, you don't, and if you're infringing a patent, you don't have to know you're infringing. You may never know about that patent until you get a letter or a lawsuit from the patent owner. Copyrights are different. You have to show that you have to show the infringer had some knowledge of it. Now, when you have something that's very famous, that's a copyrighted work, you could make, as the copyright owner, you can make the claim, well, I don't have to, there's less burden on me to prove that the infringer knew about it because everybody has seen this. Like songs, let's say, everybody's heard particular songs, so it's, you don't necessarily, your burden is probably a little bit reduced in proving that notice or that knowledge. Does that make sense?
So if I don't want someone to copy something, I need to register.
If you want to assert it, register it. And you do get, it's cheap. It's like $45, maybe $50 for the application. It's like 2 pages. I would register it. If you really have something you want to protect, like an e-novel or whatever it may be, yeah, I'd file it. Yep, you can do it online. Yep.
It's a sum total, like $45?
Yeah, it may be $50 now, but it's somewhere in that range.
No additional charges going down the line, though?
No, there's no registration fees. Patents are different. They do have maintenance fees, but no, once you have it, you have it.
So if you can do it online, do you know the website to do that?
Go to the U.S. Copyright Office. Okay. They'll have they have booklets, like explanatory booklets for every kind of registration. They do segregate them, audio, visual, music, books, so they're a little bit different.
It's neat.
Yeah.
How long are they good for?
Copyrights?
Yeah.
That's my next slide. So, for the life of the author, plus 70 years. If it's a work made for hire, and I'll get into that a little bit, what that means. Think of it, if your employer creates something for you, that's a work made for hire. It's 95 years from first publication or 120 years from creation, whichever is shorter. These all got extended from Sonny Bono, way back 15 years ago. He extended all these. So, well, we talked about, did you have a question?
No,
Okay.
I'm amazed. I didn't think that's a long time.
It is a long time, yeah.
A patent has a patent is like.
Well, it's narrower scope on a copyright. Patents are pretty broad in scope, so they they're less time. But yeah, they are.
How about a blueprint? Can you patent a blueprint? Can you copyright a blueprint?
Sure. You can copyright architectural drawings. There's a specific category for architectural drawings. Yeah, absolutely.
And they're good for that long?
Architectural drawing, yeah.
Like a machine design drawing or something? Or a clock? Suppose you have a drawing of a clock mechanism? Or
So you get into what is original.
$50. I mean,
Yeah.
it's better than $10,000.
But it becomes a question of what's original, and your scope of protection in a copyright depends on what else is out there. It's so your scope is narrower than a patent. But yeah, it's as long as it's original, and it's rare. But sometimes the Copyright Office will come back and say, what you submitted for a registration is not original.
Has your firm ever prosecuted a case for infringement of a machine design as a copyright?
We've done copyright infringement, but I can't think of an instance where we've done machine designs. No. I mean, the actual blueprint,
I hear Westinghouse and General Electric used to do it that way.
they had copyright infringement cases.
Yeah, that's how they would do business as in their patent department. I heard that from someone.
Yeah, maybe. But they certainly may have patent litigation going on the patents that cover those different designs, but I've never heard of copyright infringement for blueprints, but maybe.
Okay.
So we talked about registration, it's not required. I think we went through all that. All right, trade secrets. So this is the third category. So if you have, say you have an invention, you don't have to patent it. If you do choose to patent it, you have to make it public. You have to disclose it. You have to disclose it in detail, and in enough detail to inform somebody that's skilled in the art in that area to actually make what you're describing. You can choose, however, to keep it all trade secret and not patent it. And trade secrets at a high level, it could be anything. It could be financial, business, scientific, technical, economic information, any type of information, so long as you take reasonable steps to protect it, and that's a requirement, and it derives independent economic value from it not being known by somebody else that could use it. Those are really, at a high level, those are the two kind of parameters. There's no registration process. There's nothing you have to do to protect it or keep it as a trade secret other than taking reasonable steps to protect it. So that means a lot of different things. If you have employees, you have to have non-disclosure agreements. You should limit what employees look at those trade secrets. If you have contractors, definitely need non-disclosure agreements. So if you ever, where this comes into play is, if you own that trade secret and you're going to make a claim that somebody misappropriated it, the challenge from that defendant is they're going to say you didn't take reasonable steps to protect it. It's not really a trade secret. That's going to be the big challenge. So you have to show that you took those steps. But unlimited in duration, I mean, the famous example is the Coca-Cola recipe, right? Nobody knows what it is, I think. And they protect it under lock and key. And it's been around for years and years.
How do you prove that you have a trade secret? I mean, do you register for it?
No, you don't do anything.
How somebody down the street or next town over makes the same exact thing that you're making?
So they can do that, and let me just go to the next slide. So that is the downside to trade secrets. If somebody can figure out what you did and they haven't stolen it from you, your trade secret is no longer a trade secret. If they want to publish it, that's perfectly fine. So that's the downside, is if somebody can reverse engineer what you've done, then it's no longer a trade secret. That's why, so think about an apparatus. You've come up with an invention that is, I go back to my chair example. As soon as I make that chair and I sell it, everybody knows how I did it, unless there's so you can't protect a chair, let's say, as a trade secret. But let's say there's some material in there in the legs that makes it really strong, and nobody can figure out what that material is and what that composition is. Only I know that recipe. So I keep that as a trade secret. And as you develop these ideas, if there is a potential to keep it as a trade secret, it's something you need to think about. Do I want to patent this? Do I want the that protection or that's 20 years of protection, or do I want to keep this as a trade secret and really see if I can maintain it as that? Yeah.
Yeah, I read where what's coming in now is the new technology for blockchain to preserve the authenticity of a certain article that's been designed. Instead of copyright, they're using blockchain, and I'm still trying to wrap my head around it, but
Yeah, you and me both.
yeah, blockchain technology might be something to consider, because I'm working on starting a business with 3D printing
Okay.
and artistic sculptures that are illuminated.
Okay.
So
And we see a lot of patents on blockchain. I mean, they're coming, or patent applications coming in. That's
it's mostly right now with Bitcoin and crypto currencies,
but it's seeping in. Everybody's trying to figure out how they can leverage this in other applications. I mean, that's the golden kind of ticket right now. Yeah.
So if I have a trade secret, someone gets a hold of it and does the same thing, can they come after me saying that I stole it from them? Because there's no proof, right?
Sure. So what happens is if I sue you for misappropriating my trade secret, the first thing you're going to tell me is, well, tell me what your trade secret was. And that's the battle in these court proceedings, is you have to identify what the trade secret is. I certainly don't want to do that yet because I want to leverage. I want to know what you did.
that's where the blockchain would preserve the authenticity and the chronology of who came there first, I would think.
Well, and you can even without blockchain, you can document and you should document when you came up with these trade secrets and through lab notebooks or whatever it may be. So when you get to that litigation, you have evidence to say, I came up with this on this day or at this time frame. Here's what I did.
Even a photograph with metadata on the photograph.
Yep.
That can't be altered.
Yep.
How about if you have employees and they kind of know what your trade secrets are? How do you stop that?
I'll get to that. Yep. How do you protect yourself from? Well, you want to make sure you own that, right? And so you want non-disclosure agreements and assignment agreements. But I'll walk through that on how to do that. Somebody back there have a question? Yeah.
The example you gave on Coca-Cola or a recipe for the McDonald's special
Yeah.
sauce, these are trade secrets. These are big organizations. Why wouldn't they try to protect it with a patent?
Because if Coca-Cola is going to patent the Coke tray or the recipe, they have to tell us all what it is, and now it's out.
Yeah, the patent is the requirement for a patent is that it has to be so clear that anybody knowledgeable and skilled in the art can reproduce it from the patent.
Right. Exactly. It has to be what's called enabling. You have to put enough written description in that specification to enable somebody to make or do the process that you've patented. So we would know exactly what the percentages are, what the ingredients are, and so they've held on to that for many, many years, gotten a lot more leverage out of it as a trade secret than a patent.
The Colonel Sanders recipe is secret.
Yeah.
It arrives at Colonel Sanders. It arrives at KFC in sealed bags, and all it says is how much to use.
Does it? Yeah.
It says, and there's reputedly 49 ingredients in it.
Okay. Yeah. And that.
So there's a large number of ingredients in it.
Right.
And I think in the Coca-Cola formulation, there's probably only 2 people in the world that have that knowledge.
Yeah. And they protect it. Yeah. But special sauce is French dressing, right? All right, so, trade secrets. So just a couple other things. This gets into more the legal side of it, but just so you know, up until 2016, there was no federal trade secret protection. There was no federal trade secret laws. Everything was state law based. So if you had an employee and your business is in Connecticut, but your employee is in Michigan, you may have to go to Michigan and go under their state law. So it's a patchwork. It was a patchwork, and it still is a patchwork of state laws. That hasn't changed. But what did change in 2016, they passed what's called the Defend Trade Secrets Act, and that is now a federal law that legislates trade secrets. And now we have federal causes of action for trade secret misappropriation. So what you do is you'll have a federal claim, and you also have state law claims, and you can assert them in parallel, and they're both, for procedure reasons, they're usually both combined up in federal court. So the federal judge will hear the state law claims.
Is there an international kind of protection?
International trade secret? No.
I think you've got chickens all over the place. So.
Yeah. No, there's not.
Is there anything that has to be done in a trade secret? Is there anything that do you have to register, just like you did with the copyright or patent?
Nope. Don't have to do anything. Just protect it. Yep. And a lot of times methods. You can patent a method, right? But it's hard to find other parties that have infringed your method unless you can get into their plant and see how they're doing whatever they're doing. So sometimes you have to think through, do I want to patent my method, or do I just want to keep it as a trade secret? Because if I patent it, I'm going to tell everybody how to do it. And if I really want to enforce that patent, it's hard to do that because, again, you don't know what your competitors are doing, how they're actually, if they're using that process or not. All right, trademarks. Trademarks cover words, phrases, symbols, logos, and the purposes of a trademark is it identifies a source of goods. Coca-Cola, we all know the Coke sign, we know the Microsoft Apple with the bite out of the apple. We associate that with those particular companies and those goods and services. Trademarks are completely use-based protection. So that means I can come up with a mark today, but I have no rights in it. Only when I start to use that mark in commerce do I start to generate protection over that mark. When customers start to associate that mark with my business or my products, that's when I start to generate protectable trademark rights. And the more that you use those marks, the more what's called goodwill, the more association you build up, the more valuable and the greater protection you have in that mark. But since they're use-based, if you stop using them, you will lose your right to the mark. So it's use it or lose it. So patents, copyrights, not use-based. You don't ever have to use the patented apparatus or the apparatus that you patented, but you have the patent for 20 years from filing. You don't have to register trademarks in the U.S. That's pretty unique to the U.S. You can have generate what's called common law trademark rights just by going out there and using it. You start to generate rights, and those are protectable. They're somewhat limited. Let's say I open up a Charlie's Donut shop in Connecticut, and it's been there for 50 years. Everybody in Connecticut knows what that is, what my shop is. But it's probably, my common law rights are probably limited to Connecticut because nobody else knows outside of Connecticut. But you can register, you can file for federal trademark registration, which similar to copyrights, gives you additional advantages. After a number of years, your mark becomes incontestable, that there's a presumption that you own the mark. You can actually use the R in the circle rather than when you see the TM, that means it's not registered, or maybe it's in the process of being registered, but it gives you that right to use the R. So there are real advantages to filing trademark registrations. Yeah.
What advantages do you have if you develop a name or a logo and put the TM on it, which you can do, I understand, right away?
Yeah.
But what advantage, how far does that advantage go of putting a TM on a logo?
Well, it puts everybody on notice that you use that and consider that a trademark.
Does that stop, until you go to register it, does putting the TM on there stop someone else from using it?
It doesn't stop them, and the R doesn't stop them either. So when it's notice. But the cause of action for trademark is confusion. So even if I have my R or if I don't have an R, if I own or if I if I have a trademark registration, even if I don't have a trademark registration, I file suit because somebody else is using a mark that is either substantially similar or the same mark for the same goods and services, then I have a claim that they're confusing the marketplace. They're kind of passing themselves off as me, and everybody out there is getting confused. And they may have a less or an inferior product, and now that's causing me harm. So that's the claim. It's not so much, so the R and the TM are noticed, but it helps your case to say I took the steps to put everybody on notice of this.
But it doesn't stop someone else from using it.
It doesn't.
If I understood you.
It doesn't stop them. No. I mean, whether you have the R or not, you still have to file that same cause of action for confusion.
Sir, you were going to, before you get into ownership, I was going to ask you a question about a patent. Suppose you've been producing something for 30 or 40 years and you've sold 100,000 of them, but you never patented it.
Yep.
And it is, and there are imitators, there are competitors, but no one's ever patented any of it. Is it possible to apply for a patent?
No.
Because it's been out in the public?
Right. So U.S. laws changed a little bit on that, or a lot, back 3 or 4 years ago. But even in the old laws, that scenario, you still wouldn't be able to get a patent. So as soon as you publish or make your invention public, if you're the inventor, you have 1 year in the U.S. to file a patent application. That's different than everywhere else in the world for the most part. Everywhere else in the world is what's called absolute novelty. So if I publish my invention today, I go to a conference, I tell everybody what my idea is, I'm now barred from getting any foreign patents. That's absolute novelty. You have to file your patent application before you make any public disclosure. The U.S. has one caveat for the inventors, that if you disclose it at a conference, you have 1 year. The safest thing is, if you're going to disclose it, file your patent application before you disclose it publicly. It's the safest way to go.
Okay, thank you.
Yeah.
Getting back to trademarks for a second. Before going to market with a new trademark, logo, whatever, how do you research to find out that you might not be infringing on somebody else's right?
Yeah, so there are companies out there. Thompson is probably the top one that does trademark searches. Trying to think of the prices. We have a trademark department, but I think it's a couple $100, I think. But they'll give you a full report. They'll search. They do Google searches. They have all different databases that they search. But you can start to poke around yourself. You can look. So if you go on, it's called TESS, TESS, which is at the Patent and Trademark Office. That's their database of all registered trademarks. So if you go on there, you can type in what mark you want. It'll tell you if there's anything that is registered or at least pending. So you can start to look around, but there are companies out there that do those searches. Yeah.
There are some names that become common verbs or nouns, such as Xerox and Google.
Yep.
Does a trademark protect them, or?
No, it's the reverse. So as your mark starts to become so used in like Xerox and Google, and it hasn't gotten to that point yet, although I was just talking with somebody the other day that this issue, I think, came up recently with Google. It becomes kind of ubiquitous, and it's no longer associated with the goods and services of the company. It's just a verb. It's just what we Band-Aid, and you start to lose your trademark rights. And if you don't start to protect it and take actions to protect it, you may lose your mark. You may lose the protection of your mark. I'm not sure Band-Aid is really a mark anymore. I think it is. Yeah, because of that fact. And Xerox had some issues with that just 30 years ago. So it does become it is an issue. Kleenex, yeah.
So you have to demonstrate that you're fighting to keep it as a trademark?
Yeah, that yeah. And it's hard. I mean, how do you stop all of us from using Google as a verb? You don't.
I remember in the 70s, Xerox would take ads in certain trade publications.
Yeah, that's right.
Journalists trade publications and say Xerox is a brand name. If you're referring to the word, you have to use
Right.
photocopy.
Right, right. And you may see Google maybe start to do that. Yeah. All right. Went the wrong way. All right. So let's talk about ownership. So I say you in quotes, do you own your IP? Because you could be sitting here as an inventor, you could be sitting here as a business owner that has employees, you could be the employee, you could be the contractor. You is a relative term. And whatever hat you wear, you may or may not own the IP that you're developing. So from an ownership perspective, for patents and copyrights, there's kind of a statutory default regime for each of those. For patents, the inventor at the lowest level is presumed to be the owner. At first shot, if you invent it, you own it. So what's an inventor? An inventor is the person or persons that conceived of the idea. What's conception? And there's a lot of different definitions for conception, but inventor must form a definite and permanent idea of the complete and operable invention to establish conception. And whatever all that means is kind of the standard of what the Manual of Patent Examining and Procedure is the guidebook for the patent examiners to examine patents. It's a gigantic series of books. So that's kind of the way they describe conception, but it's a very vague kind of a definition, but you have to have a concrete idea of what your invention is. That's at a very high level. So whoever had that conception, they own it. And if you and I are working together, we may have at the same time conceived of different parts of the invention, so we both are joint inventors. And if you have joint inventors, you now have joint owners. So joint ownership brings with it a lot of different issues of, let's say you want to go out and license the invention and I don't want to, or you do go out and license it, you make a lot of money on it, do I get a piece of that? So how that works, so the federal statute has a default rule. It says unless you agree to something else or absent an agreement to the contrary, each joint owner of a patent can go out and exploit it however they want, and they don't have to share in the revenue, meaning they don't have to account to the other joint owners. They can do whatever they want. What they can't do, just as a nuance, is they can't exclusively license another party because they have a joint owner, so they can't say to that licensee, you're the only one in the world that's going to practice this invention. So that's the only limitation on it. But that's the default rule. So if you have an agreement, if you're negotiating an agreement, you want to have an agreement or a say in the agreement how joint ownership is going to work. You can agree to share in proceeds, you can agree to anything you want. That's just the default rule. Copyright is a little bit different. So copyright looks to ownership really starts with the author. That's the person who fixed whatever it is in a tangible medium. You can have joint authors as well. If you jointly author a book, you're now joint authors. Now you're joint owners. And so the copyright laws have similar default rules. It's just the reverse of the patent law. You are joint owners. You can each go out and exploit it, but you do have to account to the other joint owners. So you have to share. And just add that in, accounting, if you're a joint owner and the other joint owner is out exploiting it and making money, you're going to have to go file suit where that joint owner is, go into state court and say, I don't want an accounting, I want to know how much they made and I want a piece of it. So you have to go in each state is a little bit different. It's a state law accounting rule. All right, so that's the federal kind of statutory default. So now let's talk about employees and contractors. So the default rule for employees, unless there's an agreement that says something else, is that the employees own what they invent. Unless, and there's two exemptions or caveats to that, unless you're an employer and you've hired somebody to invent. You hire a scientist or an engineer and their purpose is to invent. Then you, as the employer, would own that IP, but there's a caveat to that. It's not assigned up to you automatically. You may have some right to go to that employee and say, hey, you're obligated to assign it to me, but the assignment hasn't taken place. And this comes up a lot when we represent companies that buy other companies, and we do due diligence. We look at these employment agreements, and if there's no assignment clause, we have to deal with that. And sometimes we can make the case that, hey, you employee, you are hired to invent, you have an obligation to assign this, and we go get those assignments. So this is one tool in that due diligence exercise where you can use that. The other one is, there's an agreement. You have an employee agreement that says you're going to sign everything up to me, employer. There's one caveat to all of that is if you hire just an employee, they're not hired to invent, but they happen to come up with a great idea, which happens. If you don't have an agreement with that employee, they own it. You get what's called shop rights. You have a right to use it, whatever it is, kind of internally in your own business. You don't want to rely on any of those default rules. You want to have employee agreements in place. And with contractors, if without an agreement in place, if the contractor develops something, typically they're going to own it unless there's agreement that says that they're going to assign it over to you. So employees and contractors, you want an agreement. There's one caveat on copyrights for both employees and contractors. So this only applies to copyrights. Sometimes I hear people will say, well, I'm an employer, I own everything the employee does because it's all work made for hire. That's not true. It doesn't apply to patents, doesn't apply anything but to copyrights. So when an employee creates copyrightable matter, let's say it's a software developer, and he creates software, that is copyrightable. It's a work made for hire. They made it in the course of their employment. So the employee is not the author. The employer is the author. There's no assignment that needs to take place. The employer is the automatic author. You don't need an agreement with the employee, although you should have one. It's by default. It's different with contractors. You can still have works made for hire with contractors, but there's only a certain number of categories in the copyright statute that copyrightable subject matter falls into works made for hire. Not everything that's copyrightable that's made by a contractor is a work made for hire. And you have to have an agreement with the contractor that acknowledges whatever that thing is a work made for hire. You don't need that with employers, you do need it with contractors. But again, always have agreements with your employees and contractors that covers all of this. And I'll give you the three steps.
So would that be only like during working hours? I mean, suppose someone on their own outside of work is dabbling with ideas.
Yeah, it's a good question. And there's some states that legislate how far you can reach and what your employees are doing. It's certainly in the course of your business, if you're using the facility, or even if you're at home and you're a scientist and you're a biotech scientist and you come up with an idea that's related to the company work, it's still going to be the company's. But if you're a biotech engineer and you're off, doing something aerospace related in your garage, it's unlikely that a court's going to say, that you employer own that. But there are some states that, and I have the states here, that say you need to tell the employees what the scope is of what you employee need to assign up to your employer, and it's limited, and it does talk about scope of employment and that sort of thing. So this is an important one. When you have those employees, if you have employees, if you have contractors, there's magic language you have to put in it. When the employee or the contractor says, I'm going to assign everything up to you, employer, or the one that has engaged the contractor, you have to say, I hereby assign. So the employee needs to say, I hereby assign. Contractor says, I hereby assign. And the magic language is, because this came up in a Supreme Court case, if you just say, if the employee says, I agree to assign, that's not an assignment. So you need to go, they may be obligated to assign, but you have to go get an assignment from them. When you say, I hereby assign, the employee says that. Once they say that the first day they start at work, whatever they create in the future, they automatically assign up. You don't have to go get anything from them. It automatically happens. So it's a present day assignment of a future right.
How about the duration of the life expectancy of this agreement? Suppose I'm working for somebody, I sign a
Assignment agreement? Yeah.
Yeah, and then I don't work for them anymore.
Yep.
And obviously I have knowledge and skills from working with them. How long is the duration that I have to stay out of their business?
So that's kind of two different things. One is there'll be a non-disclosure or confidentiality provision, so you can't take their confidential information and use it wherever you go. But
what if you leave empty-handed? No,
Yep.
no hard drives, no nothing.
right.
Empty.
So you're talking about a non-compete,
Yeah.
which is the additional protection. So some employee agreements say when you leave for 1 year, you can't be in this business. And in some states, California, you can't do it. You can't have non-competes. Most states you can. It's got to be reasonable.
Yeah, California, that's that Silicon Valley was
Yeah.
based on all that.
Right. So you can't have it.
Yeah.
But most states, it has to be reasonable in scope, which is usually a year, maybe 2, but usually a year, and reasonable in scope. You know, it's geographic scope, technological scope. It just has to be reasonable. And a year, time-wise, is usually where courts will say, yeah, that's reasonable.
Thank you.
Yep.
So would you have an employee sign a combination, non-disclosure, non-compete?
Non-disclosure, assignment, and if you want to non-compete, all in the same agreement. Yep. Yep.
And can they be in one sentence, or are they in separate
No,
sections?
I would
Three
put it.
signatures required?
No. So they can sign all. It's one document they sign once, but I put them in 3 different sections.
What if they're not in 3 different sections? What if they're like
You can
buried?
put them all together, I suppose, as long as it says what it needs to say. Did you have a question?
No.
All right. So this is the 3 things to say in that assignment agreement. Say, to the extent it's copyrightable, it's a work made for hire. So now you've acknowledged it. Number 2, if it's copyrightable but not a work made for hire, so it doesn't fit in all those categories, you employee, you contractor, you hereby assign it. And everything else, to the extent it's not copyrightable, which is trade secrets, patents, confidential information, anything else you come up with, you hereby assign. So you capture everything. So that you say those 3 things in an agreement from an assignment perspective. That doesn't cover confidential information or non-compete. That's just the assignment side of it. So these are, just so you know, you'll have it. Those are the states that have limitations on what you can do to assign employees. These states down here, those 5 states, those are the states that require you to put in the agreements the actual language in the state statute to notify the employee of their rights. And that may change over time, but that should be up to date. All right, so what time is it? All right. So let me run through this. This is my goofy example to try to explain what a patent actually gives you. So remember, it doesn't give you the right to make the thing that you patented, it gives you the right to exclude others. So at the end of every patent, a patent's like a deed on your house. It describes the metes and bounds of your invention. So a patent will have what's called a specification, which is the whole long description of what it is that your invention is. And at the back end of every patent are claims. They're numbered paragraphs, and that defines exactly what your invention is, not the written specification. So let's say an example, I got a stool, so I'm company A. So here's my claim. I have a chair, and it comprises a seat, this horizontal seat, and 2 or more legs. I guess it should be 3 or more legs, but let's say it's 2 or more legs. So I get a patent on that. So then company B comes along, and they're going to make a chair. It's got a seat, it's got 2 or more legs, but it also has a backrest. So they added an element. So company A can exclude everybody from making anything that has a seat or 2 or more legs. So can company B although they got a patent on this improvement, can company B make that chair? No. They can't, because it's got a seat and it's got 2 or more legs. So it infringes Company A's patent. So while the patent office gives this patent, it doesn't, well, let me say it this way. While the patent office says, Company B, you made a novel improvement, you put it back on the chair, so it's novel, it's non-obvious, you can get a patent on it, but that doesn't mean the patent office is saying he can actually make that chair, because there's this other patent out here that they infringe. What Company B can do is they can exclude everybody else from making anything that has a seat, 2 or more legs, and a back, which is what Company C did. They have a seat, 2 or more legs, a back, and they made it rock. So this company can stop them, so can this company. So everybody can sue Company C. Does that make sense? It's very counterintuitive.
How do the rocking chairs never get made?
It does,
So what happened, that's a good question. So that gets to licensing, right?
about 150 years ago, they used to fill books with all these standards for screw threads and bolts. Thank goodness they did that. Nobody made anything.
Well, nobody's going to get a patent on this stuff anyways, because frankly, this is probably obvious over this. They just added a backrest. But let's just assume they all get patents. But what happens is, it's a good question, and this is where you get to licensing. So Company B is going to get a letter from Company A. It says, hey, you can't make that. You're infringing. So then they'll do a deal. Company A will say, all right, I'll license you that patent. They don't have to, but they'll say, all right, I'll license you my patent. Every chair that you make, as long as it has a seat and 2 or more legs, you're going to pay me something. And that's when you get to licensing. But you don't, Company A could take the position, I don't want you to make that chair. I want to be the one that makes all these chairs. So they can file suit and try to get a court to say you're infringing that patent and you can't make it anymore.
One other question,
But
please.
they
How
could
does-
lose in court.
How does Company A get the right to make it? Or does someone have the right to make it until it's taken away? I'm getting a little confused
Yeah,
about this.
so they have the patent on anybody, they can stop anybody from making anything that has a seat and 2 or more legs.
After 40 years, the only thing you get is a rocking chair.
What do you mean?
Because the 20 years.
Yeah, when this
Company A,
expires,
And
yep.
then Company B's goes out so that the last person's in a rocking chair.
Yep. But yeah, so they can stop anybody, no matter what the configuration is, if it has a seat and 2 or more legs, it infringes that patent. It could have 10 different improvements around it. Like the rocking chair has the back, it's got the curved legs, but it still has everything that's in that patent.
That's how technology kind of grows. It gets very complicated.
Well, that's the concept is, Company C saw, presumably, B's and A's patents, they saw how they did it and they improved upon it. And that's the idea, that's the trade-off. You explain how you do your invention and everybody can improve upon it.
Suppose you've got the machine that you've been building for 30 years and you develop some bells and whistles for it. Are those patentable?
The improvements are, yeah. You may not be able to make what you got a patent on, like Company C, but you can get a patent on it if it's new and novel improvements. So what the patent office is going to do is they're going to look at that, what's been around for 30 years, look at your improvements on top of it and say, did you make an obvious tweak to this? It's not really, it's not non-obvious.
But aren't art examiners looking carefully at enhancements?
They do. I mean, the improvement patents are.
I mean, that's what the whole microprocessor industry is based on: larger, more flops, more layers, and all that.
And if you're able to make a tweak that makes it go faster or more efficient, then it's probably patentable. But you may also infringe the base patents. But yeah, and most patents are improvement patents. It's unusual that somebody comes up with something completely new. So everything's a little iteration, and bit by bit we get better and better.
So the only one that's really protected is Company A. Totally protected.
Yes, but A can't make, so A can make that. It's not to say it's not going to infringe somebody else's patent, but let's put that aside. A can make that stool, they can't put it back on it, because then they're going to infringe that patent. So they can make that.
Could someone come up with a, like a tire that doesn't wear out, doesn't go flat? They don't make the tire, but then they collect money for...
They collect a royalty, yeah. So I'll go through that, hand out all the different scenarios you can think about on that. All right, so how do you get a patent? I'll run through this. What I would suggest is if you come up with an idea, you can do a lot of searching. You can hire a search firm. What we typically do is before you sink a ton of money into filing patent applications, you spend a little bit of money, have a patent search firm, which are folks down in DC. They used to all be down in DC, but now they're everywhere with computers. And they will search to see what else is out there that may be similar to what you are doing or what you're thinking. And that really serves two purposes. It gives you a sense of whether whatever you've come up with, whether it's patentable. If you see something that's dead on in the prior art, you're probably not going to get a patent. But it also gives you a sense of where you may run into infringements. So if you're going to start to make a product, what other patents are you going to bump up against and get accused possibly of infringing? So it's a twofold exercise. So as I said before, U.S. is now a first to file, kind of a race to the patent office. There's what are called provisional applications and non-provisional applications. So because the dates are so important and getting an early date is very important because now it's a race to the patent office. You want to be the first one there. So there's that reason. Plus, when the examiner is going to examine your patent, they look at everything, all the published prior art before your date. Anything after your date of filing doesn't really matter because you've already filed. So the earlier you file a patent application, the better date you have, and it's better. So there's two ways to file patent applications. The provisional is it allows you to do nothing more than secure a date. It will sit there for a year. Nobody's ever going to look at it at the patent office. It's never going to be disclosed. It's just going to sit. It buys you a year to decide what you're going to do. But, and when you get to that year, you have to decide, am I going to do nothing? And if you do nothing, they will destroy the provisional. Nobody will ever see it. If you decide to file the non-provisional, which is the full patent application, you have to do it within a year. And so you file that, but the key to keep in mind is when you file that provisional the year before, it's got to have all the information in it through written description, enabling disclosures, pictures, whatever it may be that shows your entire invention as much as you can. So when you get to that point a year later, when you file the non-provisional, you have to have all the support, everything you say in the non-provisional, you have to be able to look back to the provisional and show the examiner, yeah, I said all that stuff a year ago. Because if you got a whole bunch of new stuff in the non-provisional, you're not going to get that early date on the new stuff. So when you file the provisional, it's cheaper, but you want to make it as robust as you can. And it gives you a chance to decide, am I going to do anything for a year? So the examiner is going to go through the process. They're going to look at your patent. They're going to look at your claims. They're going to do their own prior art search, and they're going to come back to you with what's called an office action. And they're going to say all of your claims are rejected, most likely, because it's either not novel, meaning they can find one patent that shows every single thing that you're claiming as an invention, or they're saying it's not obvious, or it is obvious. They're saying, if I combine up these two patents, it shows exactly what your invention is. And you're going to respond. You can amend the claims. You can make arguments. And this is the negotiation you have. And this is what the patent prosecutors do. They go through this negotiation with the patent office to try to get the examiner to a place either by narrowing the scope of the invention or making arguments, convincing them that it's not prior art or your invention is novel and not obvious. And you get to the point where they give you a notice of allowance and you get a patent. Yeah.
Do you, if you want to go forward after the year, do you change the status from provisional to non-provisional at that point?
Yes, you actually file a non-provisional. It's a new application.
But not until the year is up.
You can do it whenever within the year. You don't have to wait.
You can do it anytime within the year.
Yep. Costs, it's depends what the technology is. If it's simple mechanical, going through the whole process could be $10,000, $12,000. If it's more technological, advanced, if it's biotech, it goes up from there. And that includes patent, preparing the patent application and going through the process with the patent office.
When you say go up from there, how high?
Could be anything. It really could. The more, if it's biotech and you're fighting with and you got millions and millions of dollars on the line, it could get very expensive. It could be 15, 20,000, typically somewhere in that ballpark.
And the timeline?
Yeah, good question. Really depends on the patent office. So if it's simple mechanical, could be 3 years.
Are there ways to improve the timeline?
So there are ways to accelerate it. You pay more money. So there is accelerated examination, which is a special process. You kind of do a lot of the work for the examiner. So it's more expensive, but yeah, it does move faster. All right, so let's talk about, now you own your IP, you got your patent, or your set of patents, what can you do with it? So you can start to make your products, whatever your apparatus, but again, it doesn't mean you're not going to infringe somebody else's patents, but you can provide services. If your patent covers a method and that method is kind of mixed in within a service, you can provide the services, start to generate revenue.
Before the patent's issued, or as soon as the provisional's in, you can start to market?
Yeah. Yeah, exactly. And you can say it's patent pending, but you have the coverage. As long as the provisional covers everything that covers your invention and it describes the full invention.
So
yeah.
what if the provisional application crashes and the examiners say that you're not granted?
So if you get to the point where you just have the patent examiners there are appeal processes you can go through. But if you get to the point, where you don't have patent protection, that's the chance. Usually, you can change the scope of the claims. You can make them very narrow, but it's very easy from a third-party perspective to not infringe it. And that's the trick, is to make it broad enough that it's not invalid over all the prior art, but it's not so narrow that third parties can easily get around it. And that's the magic of patent prosecutors. So you can exploit the technology yourself, or you can license others to exploit the technology. And we'll talk about licensing. You also have the right to enforce your patents. If somebody's making your product, they're competing with you, even if they're not competing with you, they're making your product, they're infringing, you can go sue them and collect damages. You can get a royalty, a reasonable royalty on whatever amounts they've generated. Sometimes you can get what's called lost profits on the amounts they've generated. You can get all their profits. Much harder to do than a reasonable royalty, but you can get damages. Yeah.
You could sell your patent, and with the patent office recognize that.
That's the next page.
So you can sell your patents, absolutely, done all the time. You can license them, you can sell them. They're personal property is really what they are. So the patent comes with a bundle of rights. It gives you a right to make, use, sell, offer for sale, and import. So you can license any one of those. Usually all of them are licensed. So the types of licenses at a broad level are either exclusive or non-exclusive. So if you own the patent, if you don't want to commercialize this at all yourself, you just want to license it out, there's a lot of different things to think about. If you want to exclusively license it, if you're not going to restrict it to a field of use, let's say, your exclusive licensee will have sole control over the exploitation of that technology. You're putting all of your eggs in one basket with that licensee, and sometimes that happens. If your patent is kind of structured in a way that you can do this. You can split it up into different technology areas. If the patent's broad enough that it may cover aerospace, but it may also cover, I don't know, some industrial application that's different than aerospace, you can say to one company, I'll give you a license exclusively in aerospace, I'll give you the other company in the industrial application. And you can chop it up however you like. So you can have non-exclusive is just as that. You can have as many non-exclusive licensees as you want. In a non-exclusive license, really all you're saying to the non-exclusive licensee is, you can make that product, I'm not going to sue, I promise I won't sue you, and you're going to pay me money. That's really all that's going on in a very simple way in a non-exclusive license. You can also split it up into geographic limitations. You can really slice and dice it, the field of the license, however you want. One thing I just want to explain, so another right that comes with patents, unique to patents, are what are called have-made rights. So let's say you own the patent, you're going to license it out to company A, but they don't really have manufacturing facilities. They're going to sell it, they're going to commercialize it and market it, so they need to go to a contract manufacturer and have them make it for them. So there is a particular right for patents that says you as the licensor can give the licensee these have-made rights, which is not unusual, it's pretty frequent. So the question is, well, what happens if the agreement doesn't say anything about it? It just says you have the right to make, use, and sell, but it doesn't say whether you can or can't, whether you do or don't have these have-made rights. So the case says if it is silent on have-made rights, they are implicitly included. So you as a licensee have them unless they are specifically excluded. So if you're the licensor, and for whatever reason, if you don't want to give those have-made rights, you have to say that. And it's the reverse of something else I'll talk about in a second. Does that make sense?
Yeah, that's very important, because if you have an invention and you can't make it, but there are experts in art that can make these things handily, and so the have-made rights, that's reasonable currency. That's a common form of practice, isn't it?
It is.
It's a common form.
It is. So if you're the licensee, you don't want to rely on the default rule that it's silent and I have these implicit have-made rights. You want have-made rights. You want to say that in the license grant, that I have the right to make, have made, use, offer for sale, sell, and import is what is the bundle of rights that you want.
Yep.
So sublicensing is a little bit different. So a have-made right is not a sublicense. It's just letting a contract manufacturer make it for the licensee. A sublicense right means, take the situation, you own the patent, you're going to license company A, and they are going to in turn license somebody else to actually make the product. So they're going to step into your shoes kind of as collecting royalties, and they're going to control who is what's now the sub-licensee. So you're, as a patent owner, you're kind of one step removed. So you don't have to give those rights as a licensor. You can say, you licensee have no right to sub-license. That's not uncommon at all, and prevent those. Or you can say, yes, you do have the right to sub-license under these particular conditions, and you may dictate, you need to come get my consent first, you need to show me the license, there's 1,000 different ways you can handle that. But the point I wanted to make here was, if the license is silent on sub-license rights, it's the reverse of have-made rights. So if it's silent on sub-license rights, the licensee typically does not get the right to sub-license. Where they may have the implicit right to the have-made rights, they don't get the sub-licensing rights. So if you're a licensee...
Where is that? Is that in the United States of America, or is that other places?
That's dictated by state law, but that's pretty much the consensus among state courts and federal courts, is if it's not in there, you don't have it.
So the licensor, the inventor, would want to say you have no right to sub-license.
Yeah. So when I do these, if I represent the licensor, and I'll ask the question, do you want them to sub-license? If it's no,
50 states.
Well, so each agreement will be governed. But you'll say in the agreement, this agreement is governed by the laws of Connecticut, or you'll pick a state law. You should, and then so when if there's going to be a lawsuit over that agreement, Connecticut law will govern, or whatever state you pick.
Well, it's better not having a lawsuit.
Yeah.
So you said half-made rights are implicit, basically, so.
They are. Sub-licensing rights are not. It's a little murky if you have an exclusive license, if you're the exclusive licensee, because you have a little bit more rights as an exclusive licensee than a non-exclusive. You know, you're how do I say this? You are preventing the licensor from actually practicing their patent. So you have a little bit more, you can stop them from doing that. So you have a little bit more than the non-exclusive. So sometimes courts may say, well, if you're the exclusive licensee, you have a little bit more along the way of rights. Maybe you can have this implicit sub-license. But it really depends on the state law.
Yeah, thank you, sir.
Yep. One other thing, so if you are contemplating sub-licensing, if you're the sub-licensee, you're dealing with the licensee, right? So you have an agreement with them, but then there's a base agreement between the licensor and the licensee. So if you're the sub-licensee, if you're ever in that position, you want to ask the question, well, what happens if the base agreement gets terminated? What happens to my rights? And sometimes, a lot of times, the base agreement between the licensor and the licensee doesn't say anything about it. It'll say, yes, you have the right to sub-license, but it'll never say what happens. So you should, in that agreement, in the base agreement, that should be agreed upon. What does happen? And there's a lot of different ways you can handle that, but it should say it, because it's going to be a question from the sub-licensee.
Could you give a brief example of what a sub-license is, for example?
I own a patent on making chairs. I license it to you. You are not really going to commercialize it. I give you the right to sub-license it. So then you do a deal, you enter into an agreement with you. You're actually going to make the chairs. So you two have an agreement. You have sub-licensed the rights to the patent. So my license to you is a direct license, and you've taken those rights and sub-licensed them.
So it's not murky at all. The inventor should expressly prohibit it.
If the licensor doesn't, if I'm the licensor and I don't want you to enter into that agreement, I only want you to exploit it.
Why not? I mean, you could have your brother-in-law sub-license, and that cuts out the licensor entirely.
Right. Well, if I'm the licensor too, I want to know who's exploiting this. I want to make sure especially in the exclusive world, I want to make sure whoever is exploiting this, they actually have the capacity and the capability to do it. So I may not want you to sub-license it at all, because I like you, I trust you, and that's it. So I don't want you to have that further right. But if I do give you that right, I may say, yeah, you need to come to me first and get my consent. I need to know who it is. And there's a lot of different conditions you can put in there before you can get over the hump where you actually can sub-license it.
Yeah, but if somebody approaches as an attorney with a patent in their hand and says they want to license it, I would automatically put that in there.
Well, I would think there are cases when a licensee would have no interest in taking on a license unless they could have a sub-license. If this person can't make it,
I don't know,
but he thinks there's value, if he can get someone else to make it.
If I'm the licensor, I would say to you, if that's great, if you have this great potential sub-licensee that you think will do a great job, come talk to me and get my consent. Yeah. But I don't want to give you the blind right just to go sub-license to whoever you want, because it's my patent. And especially when, as I say, when it's exclusive, because I've given you that territory. I want to know, I think you have the capability to go exploit this, but I'm not sure whoever you choose to do it actually does.
The milking stool patent, the milking stool inventor could give you a right to make rocking chairs if you sub-license, if your licensee wants to make chairs with backs, they would grant the sub-license to do that, wouldn't they?
No.
No?
Maybe. Yes. Maybe. Yes. They would, to the rocking chair company, yes. If they wanted, if the rocking chair company came to them, the licensee, and said, hey, I want to make rocking chairs, and grant me the sub-license, then yes.
So in a fundamental sense, I have a friend that invented the bagel biter, and he told me that he wished he invented the horizontal bagel biter in addition to the vertical bagel biter. That's the kind of a guillotine slicer for bagels. And he made a lot of money on it, 18 years of holding the patent. And but the first permutations of it that got out there in commercial applications were automatic dead machines that used the device horizontally.
And his claims were to vertical?
Yeah.
Yeah. Well, that's when you get to the patent claims.
He didn't license it. So.
Yeah. Yeah, but when you're thinking about those inventions, hey, that's an improvement. Maybe it's an improvement, but it's different. It's it's new and novel. All right, so let's talk about money. Typically, there's a lot of ways to split up royalties, but typically you want an upfront royalty, you want some cash up front. Licensee has some skin in the game. You want to make it non-refundable as a licensor. And typically you then have ongoing royalties. Mostly the royalties are based on a percentage of net sales. You can debate as to what net sales means. It's usually gross sales, and whatever you agree to pull out. Licensees are going to want to pull out overhead and all sorts of different stuff, and that gets, as a licensor, you don't want any of that. It's usually just returns and insurance and pretty limited amount of things. This, if you're going to exclusively license something, again, you're shutting yourself out. You're going to rely totally on your exclusive licensee, so you want to hold them to a higher standard. And there's a couple of things you do. You say, I want annual minimums. I don't care if you don't sell any products, but you're going to pay me $500,000 a year. And in addition to that, I want you to reach certain milestones. I want you to have 1,000 customers by the end of a year, whatever the milestones may be. And the reason for those two things is at the end of if either or both of those are not hit, it gives you the right as a licensor to either convert it to a non-exclusive, so you can go out and find others, or you can terminate the agreement. So you're not stuck with this exclusive licensee that's kind of shelved the product. Just one caveat here down on the, if you ever base a royalty on a unit, I'm going to pay you $2 a unit. If you're the licensee, you got to think through, well, when do I owe that money? You may make 1,000 units that you're going to have sit in a warehouse for 6 months. You don't want to pay $2 a unit when you make them. You want to pay $2 a unit when you sell them. Licensor wants $2 a unit when you make them. So a lot of times it's silent on when that is, but you want to negotiate that. This is the legal side. On reps and warranties, licensors aren't going to make any reps and warranties about your products because they can't control how you make your product. So they're not going to. Typically, they're going to say, I'm not going to say it doesn't infringe. I'm not going to say any of that. What you may try to get from a license, if you're a licensee, to have the licensor say, well, at least tell me to the best of your knowledge, your patent's valid, meaning they don't know of any prior art out there that's going to invalidate their patent. And sometimes you get that. Sometimes they just say, I'm not going to give you anything. If I represent the licensor, I'd say I'm just not going to give you anything. You're on your own. Patent enforcement. So you own your patent. You want to, if you can, control when you're going to enforce it, when you're going to sue somebody. The reason for that is when you enforce that patent, it will be challenged immediately, the validity of it, the enforceability of it, and maybe a host of other things. So you want to be in control of at least when that may happen. And sometimes, well, let me say this first. Non-exclusive licensees have no ability as a licensee to assert a patent that they have a license to because they're non-exclusive. They don't have enough rights. Exclusive licensees, because they have some more rights, sometimes they have the right to actually take the patent that they have a license to and they can go to court and they can sue on it. and they can have a right to collect damages. So as a licensor, you need to think that through. Are you okay with this exclusive person going out and suing on the patent, and now the validity of it's going to be challenged, and that's going to affect if you have a patent or not at the end of the day? So that's all a negotiation, how much control you give your exclusive licensee to actually assert your patent, especially if you split it up in a lot of different application areas. If your patent gets invalidated in their lawsuit, it's going to affect everything else and all your other revenue streams. I think we're running out of time here.
We got through it, though.
Just one thing on the term of the patent. If your patent license is if your license is strictly for patents, you cannot charge royalties beyond the expiration of the patent. It's what's called patent misuse. You can say, and what is typically said is, you will pay royalties up until the last to expire patent that I've licensed to you, but it's got to end then. And this just went back up to the Supreme Court, and they reaffirmed the whole thing. So what you can do is you can say, as a licensor, I'm going to give you a license to patents, and I'm going to also give you a license to some know-how, whatever that may be. So at the end of the day, when the patents expire, let's say it's a 5% royalty with everything, know-how and patents, you can say, well, when that happens and the patents expire, then I'm going to reduce it down to 2%, just whatever the value of the ongoing know-how is. So you can continue to get some, if you can convince a licensee to take that deal, you can continue to get some revenue. And the Supreme Court said that's fine, you can do that, it's just got to be a fair adjustment to take into the fact that the patent has expired. Oh, the wrong way. One last thing. So you've taken a license to a patent. You want to stop paying. You think the patent's invalid, and you want to be done with it. The old law was, in order to do that, you had to breach the agreement. You had to stop paying royalties. You couldn't file suit because you were a licensee. So you actually had to put yourself in peril and breach the agreement and stop paying. New law is, the courts say, even though if you're a licensee, you can go ahead and file suit, and you can continue to pay royalties. You can challenge the validity of the patent. You don't need to breach the agreement. But what that means is that the licensor can't countersue you for infringement because you still have a license. So it's really a one-way lawsuit. There's a lot of different ways to deal with that as a licensor. You can have them pay a big, huge upfront amount that's non-refundable. So if they do challenge it later on, you have some money in the door. You can say that if you challenge it, you're unsuccessful, and my patent lives on, I'm going to triple your royalties. So they have some downside. You can say, if you challenge it, I have the right to terminate it. That one is up in the air as to whether it's enforceable or not. Everybody has questions on that, but at this point, I haven't seen a case that says it's not enforceable. But I suspect if it ever gets challenged, it may have some issues. Oops. Just one last thing on transferability. If you own a patent and you are licensing it out, you want to make sure to dictate when your licensee can transfer it. You don't want to let them just assign it to anybody. And you want to recognize what happens if a company comes in and acquires that licensee. Does the acquiring company, if Google comes in and buys that startup that you just licensed, does Google now have a license to your patent? And maybe that's okay. If it's a royalty-based percentage, that's great. Maybe it's not. So you got to think that through, what happens on that succession. All right. I think I went about 5 minutes over. Sorry. That's it. Any questions? Yeah.
What if you want to publish or write a letter to the like say the governor, and they respond? Is that like publishing your idea, or is that considered publishing, disclosing your idea to the public, or and they say it's a great thing? Or,
if you sent a letter to the governor with your invention disclosed in it,
right?
So that letter is a disclosure. Because the governor has no obligation of confidentiality, right? Unless you have some agreement with the governor that he's going to keep it confidential. So your letter is the disclosure. So if you're going to disclose anything to a third party, you can do it and only do it under a non-disclosure agreement, and that will prevent the invention from being public for purposes of preventing you from filing a patent application. Okay, so you have to have that non-disclosure agreement in place.
I was a member of an inventors club, and we had a non-disclosure agreement that we had public meetings and we had private meetings, and we signed a non-disclosure amongst ourselves that anybody in the room was subject to the non-disclosure, and we'd help each other brainstorm like a studio, like a design studio, a skunk works
Yeah.
tank. So you collaborate with people who are also collaborating, design team, because you get a lot better product if you get, you know, because you can only see what you can see, and then other people that are, creative help you, and then everybody's subject to non-disclosure. Nobody takes your idea because you help them next time.
Right. Well, you need to be careful when you say nobody else takes your idea.
Well,
because
they take it, but it doesn't get far. It's just
Yeah.
it's a little bit of written protection that it's enforceable.
Yeah. Yeah.
The
But you do need to be careful on ownership, because everybody could come up with, you could have 4 people come up with the same idea, or, a joint, now you have joint ownership, right?
Yeah.
Joint inventors, how does ownership
Oh,
work?
no, there's no doubt about it.
Yeah.
There's just no doubt about it, because in order for any, like, that's why they have 100, send over 100 of your best guys and we'll design a missile guidance system for you.
Yeah.
100 people, it takes 100 people to do that, because everybody has to work together.
Yeah, yeah. I have clients that'll, the engineers will start to work with other companies, and they'll be 6 months in, but there's no agreement in place as to who owns what. They've come up with something great, and we need to kind of backtrack and paper it and make sure we figure out who owns what.
These places like Reset,
Yep.
the Valley Venture Mentors, they're a little dangerous for inventors per se, but not for entrepreneurs. But if you're an inventor per se and you have patentable idea, when you go out into that scenario, inventors do have to work in secret until disclosure.
It's true.
And that's why the Clinton Gore provisional patent practice, whoever did it, but the provisional patent is your friend. Because you get everything you can together in terms of claims, ideation, drawing sketches, claims, basic operation, and you file that. It gives you 1 year to decide commercially, is it valuable and what can I do with it.
Right.
So it's cheap.
It is cheap. Yep. Gives you a year, buys you a year to decide what you're going to do. Yep. All right.
Thank you so much.
Yeah, thank you. Appreciate it.
Funding for Simsbury Community Television is provided in part by contributions from viewers like you. Thank you.